the best pro bono opportunities that you can take on, because it is, sorry, I was just muted. It's limited in scope and time. The commitment is really not that significant, but the impact that you can have is enormous. And the difference you can make in particularly a family's life, when you're helping them to care for an incapacitated person, is just, can't be described. It's really meaningful. It's important, but as I said, it is not going to take over your life and require so much time that it becomes untenable. So thank you for being here. We're going to dig into all the details. Tim and I will sort of go back and forth and probably jump in with one another. You should also feel free to jump in. We have some people on this call who do quite a bit of guardianship, so we'd love to hear from you too if you have ideas or things that we haven't mentioned. And we're open to questions, so please feel free to jump in and stop us at any point too. So before we get started, Tim, is there anything you wanted to mention?
No, I think that you've covered it all, Kathy. I mean, that you're right that, a nice thing about guardianship matters, and particularly VIP guardianship matters, is VIP does a very good job of vetting the clients, and is very helpful in ensuring that that this is a situation that does require a guardianship, and guardianship matters are can get through the court process much more quickly than almost any other civil type of matter, and I agree wholeheartedly. It's my experience. The families who you help, you have no idea how grateful they are and will be to you, how much they appreciate the help that you give them, and just how important it is. Because when a guardianship is needed, it is really needed, and it is not, because guardianships are in the orphans court, a place that a lot of lawyers never choose to enter. There's can be some intimidation factor to it, I guess. But what we're going to show you today is that certainly, especially as it relates to a guardianship matter, it's anyone who's willing to pay attention can learn how to handle one and handle it well.
I agree. And I think it might be helpful just to sort of set the stage a little bit and have everybody kind of think about and understand why these matters come about and how they come about, sort of the big picture. And the big picture is that when anyone reaches the age of 18, in the eyes of the law, they have capacity. Now, that is not always the case. Sadly, we know because of perhaps a birth injury or some other accident or injury or intellectual disability, there are those who reach the age of 18 and they're unable to make decisions on their own about their medical care, about their finances, and they need someone to make those decisions for them. And we'll go into all the standards for that. So oftentimes when a parent is caring for their child, their now adult child, they soon realize that in order to speak with their child's doctor, to make decisions about their child's finances, they need to have guardianship. And it's a very scary, intimidating process for many people, because this is their child. They should be able to just make these decisions. And yet, because of HIPAA and other rules, requirements by banks, they can't make those decisions. And so it can feel very scary for them. And so this is a process by which you can help them to be able to make those decisions for their loved one. Another situation that arises, of course, is as people age. Alzheimer's, dementia, other conditions, again, maybe a brain injury, they can cause someone who had capacity to lose capacity. And in those instances, it's also necessary to seek guardianship unless, and this is a very big unless, and if I get nothing else through today, I hope I get this through, unless powers of attorney, valid powers of attorney are in place for both healthcare and financial. So if you have not done your own documents, if you do not have powers of attorney in place, if your loved ones don't have powers of attorney in place, please go do them. It's amazing. It's the joke, right, about the son of the shoemaker who always has holes in his shoes. It's amazing how many lawyers are walking around without their own advanced planning documents done. And so I want to make a big plug for doing that and for encouraging your loved ones to do the same, because as you'll see, we're going to make this hopefully as easy as possible. We'll try to demystify it, but it's a process and it's difficult, and there are requirements of guardians that are far more onerous than agents under powers of attorney. So get your documents done. Tim, did you want to mention anything else before we?
No, I would say that, and because I will periodically get a call from a family in a panic situation where someone was in a terrible car accident, and now they are, whether they are in a coma or they are otherwise unable to make decisions, and they do not have a power of attorney in place, and as Kathy mentioned, when in that situation, because of HIPAA, the doctors simply are unable to take direction from anyone. And so, sometimes at a most critical, a time of critical need, there is literally no one with legal authority to speak for someone. And so it's so important for people who have the capacity to prepare, to sign a power of attorney, to name an agent to serve for them if they become incapacitated, to do that. Because otherwise you risk putting your family or whoever, the loved ones of your loved ones, in a position where they may have to scramble and then seek an emergency guardianship, which is something that we'll talk about in just a little bit.
Great. So I think we can move on to our first main slide. So why should you handle a guardianship case? You have lots of options. There are lots of wonderful pro bono opportunities out there, and I hope you avail yourself of all of those opportunities. But I really think, as I said at the start, that guardianship is a special one and a particularly uniquely well fitted for pro bono opportunity. We already talked on about how meaningful it is to the families, and that is certainly true. It is also, and I'm speaking particularly now to some of our younger attorneys who are looking for opportunities and training for on their feet experience in court. It is a great opportunity to have a client of your own, to prepare a witness to testify, to do a direct examination, to be on your feet in court. And yet there's no one on the other side. It's not an adversarial process. So you get your feet wet by doing this without perhaps some of the intimidation factor of some of the other courtroom cases that you could take. And as we mentioned, it's not a huge commitment of time. I would say from start to finish, and I don't know, Tim, if you would agree with this, but I think 15 to 20 hours tops for someone new at doing this is all that you would need for one of these cases, particularly with the materials and the forms that we've provided. And that's including the time spent meeting with your client, preparing for the hearing, and attending the hearing. Do you think that's a fair estimate, Tim?
I do. That would have been I would have given that very same estimate.
Great. So why don't we move on to the next slide? I think it's important we go over a little bit of the vocabulary, because some of this is important, and as Tim said, in the orphans court, it can feel a little intimidating, although I hope it won't. I actually find it's a pretty genteel, nice place to practice for the most part, and the practitioners tend to be really very wonderful and civil. So it shouldn't be an intimidating place, but it sometimes can be. And I think that one of the things that helps is by knowing all of the vocabulary, so you sound and know what you're talking about. So what is a guardian? It's someone who has the legal authority to act for someone else. It's that simple. It is a fiduciary relationship, and so it is necessary that the guardian act on the person's behalf and in the person's best interests. We can move on, please. There are two types of guardianship estates. There can be a guardian of a minor's estate, and that, of course, is for those under the age of 18. And then after the age of 18, for those who have been declared incapacitated by the court, the guardianship of an incapacitated person's estate. So for the purposes of today in this training and the VIP cases that you would be taking, we are talking about incapacitated persons' estates only. So you can move on, Denise. So we're only talking about incapacitated persons' estates, and it's important. And again, this is one of those things that's going to make you sound, like you know what you're talking about, which you will. We don't use the word beneficiary when referring to the incapacitated person. We use the word ward, which sometimes beneficiary is something I think we're used to using, but that refers only to the beneficiary of a trust. But again, it's also a fiduciary relationship. Moving on. There are two separate types of guardians of an incapacitated person. And these are, I think, things that will be kind of common sense. One is guardian of the estate, and that's financial affairs of the ward. The other is guardian of the person, and that's the guardian who has the right to make decisions about things like medical care, where the person lives, goes to school, activities. I liken that mostly to sort of, it's very similar to like what a parent can decide for a child. Moving on. It's also important to remember that guardianships can be both plenary or limited. So plenary, of course, is total, when someone is unable to manage their own affairs completely and totally, and limited is a partial incapacity. So it may be that that the person is unable to incapable of handling some aspects of their affairs, but not all. And particularly, this can come in sometimes with particularly sophisticated financial issues where maybe the person can make basic decisions, but there are some things beyond their capacity. And I would say that for VIP cases, I would be very, very surprised if you're not seeking plenary guardianship of both guardian of the estate and person, because the folks that we're going to be seeing through VIP cases will have total incapacity. So, and if you find that that is not the case, please reach out to Tim or to me and we can walk you through it. But Tim, do you agree? I mean, limited guardianships I find are very, very unusual.
They are, and they are, and although it's interesting because under the statute that we'll be talking about in a little bit, there is there's a sort of a preference, if you will, for, because the idea is, if you think about a guardianship, the net result of a guardianship is that a person loses all of their constitutional rights to decide where they will live, what they will eat, what will happen with their money, you name it. Effectively, all of your rights are handed to another person to make decisions for you. And so with that in mind, the statute has a preference for so-called limited guardianships. And when they modified the statute a number of years ago to really sort of amplify that language, I think people like Kathy and me thought that we would see more so-called limited guardianships. And I think what most practitioners and orphan court judges have learned is very difficult to craft a limited guardianship order to sort of carve out certain specific things. And so, but where you may see it in a non-VIP case is as Kathy had mentioned, like maybe, perhaps a person with a significant amount of money, somebody else will be put sort of in charge of investing that money and handling most of it, but perhaps the incapacitated person will be given the ability to, have a certain amount of money put into their bank account every month that they are free to spend as they wish. But indeed, in VIP cases, I have never had one in which it was just not obviously a situation that required a so-called plenary guardianship.
And one thing I would mention, we're going to talk quite a bit about this, but you don't need to make decisions or really worry about, is this person incapacitated or not? Do they have these abilities? We're going to talk a lot about this, but that that decision, that determination is made based on medical evidence. And so there's an evaluation done by a doctor who is going to provide that. So if you're sort of sitting there thinking, how am I going to be able to know? Those decisions are made by a doctor. So if we can move on to the next slide, please. So it's important to know what exactly an incapacitated person is. And this is really the crux of what we are talking about today. And an incapacitated person is an adult. Again, we have separate minors guardianship estates whose ability to receive and evaluate information effectively and communicate decisions is impaired to a significant extent, to such a significant extent that they're partially or totally unable to manage financial resources or to meet essential requirements for physical health and safety. So the focus really is on the alleged incapacitated person's ability to evaluate information and communicate decisions. So that is the basis on which it is decided if someone is in fact incapacitated. So with that, oh, and I will mention also the statute that we cite there is from what we call in this field, the PEF code, the Probate Estate and Fiduciary Code. And that is 5501, and we included that in your materials, is where you will go for all the statutory source material for this. So Tim, unless you have anything else to add, I will turn this over to you.
I'll just comment on, there was a little talk about, of guardians of a minor's estate. And so, and you won't see those in a VIP case, in case anybody's wondering, well, why would you need one? That will typically be because I take a step back and say, right, parents do get to make medical decisions for their minor children. And so when guardianships become necessary for minors, typically if the minor perhaps was in some sort of accident or with some sort of injury or there was some sort of birth injury type of case, and then there is litigation that creates a settlement or verdict amount of funds that end up being in the hands that would otherwise be in the hands of a minor, and so the court will appoint a guardian of the minor's estate. And frankly, typically in Philadelphia County, that guardian estate will never be the parents. And so because the system has learned a little bit about that, and so will typically be some third party. All right.
And if I may jump in real quick, I just wanted to note that VIP has seen a couple of these minor estate cases recently. We had about 2, and in those both instances, it was the other parent passed away and left a substantial insurance policy to the minor child. So right. In that case, the parent came to us, but I was going to ask you to speak on it later if you could.
Yeah, and so that's a great point, Denise. Then, and so because to the extent that you might get one, you'll need to deal with that simple idea that parents find it offensive, frankly, typically that well, what do you mean I'm not in charge of this money? And so and you have to explain to them, look, I'm sure you're as honest as the day is long and you're the nicest person and you would never do anything bad. But I am here to tell you that the system, if you will, has seen too many parents who made bad decisions with their children's money. And so no matter how good you could, I don't care what your resume looks like, you will simply never be named the guardian of your child's estate. And so just, and it's for the benefit of everyone. Okay, next page. So as Kathy was just mentioning, the guardianship statute itself, it begins at Title 20 of the Pennsylvania statutes, otherwise known as to us in the Orphans Court as the PEF code. It's section 5501 and going forward. That's Exhibit 1 of your materials. Also Chapter 14 of the Pennsylvania Orphans Court rules, which is in Exhibit 2. And then Chapter 14 of the Philadelphia County Orphans Court rules, and there's certain things in the appendix to those rules that we have as Exhibit 3. So because yes, guess what? Just like anywhere else, there are rules that apply, and so it's helpful to familiarize yourself both with the with the Pennsylvania Orphans Court rules that are relevant to guardianship cases and the Philadelphia County local rules. Next slide. And so as Kathy already mentioned, we talked a little bit about it, right? Is this idea that, you know, if a person did not make, if a person who had legal capacity, who was 18 or over, and had legal capacity and now has lost it for any number of reasons, and no longer has the ability to sign a power of attorney, then that's, you know, you're going to end up in guardianship land, because, you know, because you do have to have a requisite level of capacity in order to sign a power of attorney document. And where you'll see in a lot of VIP cases is that when, you know, when a disabled child turns 18. Next slide. And so who can file? Well, it's, you know, under the statute, anyone who is interested in the alleged incapacitated person's welfare may file a petition to appoint a guardian. It is typically filed, you know, most typically filed by a parent or a child of an older parent or grandparent or grandchild, but it can be filed by, you know, by a neighbor or a close friend, or, and where you will also see, oftentimes in Philadelphia, the guardianship actions will be filed by the Philadelphia Corporation for Aging when they are notified about a situation that's, you know, people can call the Philadelphia Corporation for Aging if they sense that an older neighbor or friend or anyone, an older person typically, is in need of a guardian. And until June 1 of 2019, there used to be a requirement that the guardian be a citizen of the United States and be able to speak, read, and write the English language, sort of in recognition of our ever changing society. You know, thankfully that rule is no longer in effect, because it was preventing people, very good people who are otherwise, you know, simply because they could not speak English from, but they might otherwise be the absolute perfect guardian for this person. And so thankfully that rule no longer exists.
Can I jump in just another second to bother you? So we actually saw an issue with this recently. A judge denied one of our clients' petition because he said she couldn't speak English and that she should only refile if she could come back with a co-guardian. Do either of you have any experience with that you want to touch on really briefly, or anything to add to it?
No, I have not. I have not seen that. I mean, I'll note that, you know, we do have some newish orphans court judges in Philadelphia, and so perhaps the judge may not have been familiar with the rule, and so, you know, so you know, that's always a fine line that one walks. But, you know, if I had been in that file, you know, I would have done my best to point out to the judge that that's not actually a requirement, and so, and that's, frankly, that's an issue that, you know, you could succeed on appeal, I suspect, on that issue.
I agree, and maybe it's something that we can talk offline about too, about whether we're going to see a trend with that or not, because I think that's something that we should try to nip in the bud.
Yeah. Yes.
But that should not, as Tim said, that should not be the issue. In my opinion, that should not have been the decision. But without knowing more, it's hard to say. But I think that we should talk offline about it as well.
Thank you both.
Okay. Next slide. So, all right. So, in who can be, you know, for whom can the Pennsylvania courts appoint a guardian? Well, it's a resident of the Commonwealth or a non-resident who owns property in the Commonwealth. And so, where I don't think you'll really see this happen so much in VIP cases, you know, where this issue can arise in you know, contested guardianship matters involving people with more significant assets, can be What happens if somebody who is incapacitated is moved from one state to another? Like they've lived in New Jersey their whole life, but they went to one child went and picked mom up from New Jersey and brought her over to Pennsylvania, and now files a guardianship in Pennsylvania. You can have an argument there under a theory that an incapacitated person has no ability to change their legal domicile. But typically, this is not an issue that is ever going to be a concern in a VIP guardianship matter. And as noted in the slide, if a guardian has already been appointed in another state, then a Pennsylvania court will give preference to that foreign guardian and would presumptively appoint that same person if a guardianship is filed in Pennsylvania. Where do we go? We go to the orphans court, and so which is it is a division of the Court of Common Pleas. It is the court which has jurisdiction to declare an individual to be incapacitated and to appoint a guardian. Where do you file? It should be filed in the county where the alleged incapacitated person resides, and you have the PEF code site there. So, and again, in the VIP case, it's always going to be a Philadelphia resident. You will never have a question about whether you're in the right county or not. Here's something that's very different about guardianship practice from regular civil litigation. There is, and you'll see it in your forms. You have to give a written notice to the alleged incapacitated person in so-called large type and simple language. And it is a court mandated notice that basically notifies them a guardianship action has been filed. If a guardian is appointed, you will lose the ability to make decisions about yourself and about your property. This is a very, it's telling this person, this is a very serious matter. You have the right to an attorney, and so on. And you have to serve the petition on the alleged incapacitated person at least 20 days before the hearing. And unlike in the regular civil litigation where a process server can just show up at your door and say, "Hi, are you Kathy Ochroch?" Yes. Okay. Well, here you've been served, and turn and hightail it out of there. When you serve a guardianship petition, you must read the written notice, the important notice. You also must read the entire guardianship petition to the subject of the guardianship petition. And what the statute says is, that you should use language that the person is, most likely to understand. And so you don't always have to be, read every single word, but you do have to convey to the person, look, this is what is being said about you. And again, in the VIP case, it's, oftentimes, and you may almost feel a little bit weird about it, if you will, because you may be reading this to someone who cannot understand one word that you're saying. And nevertheless, you must file a certification with the court that you have done that. And so, and again, it's all part of this idea that because a guardianship is such a serious proceeding that is going to take away someone's constitutional rights, that there are these added procedural requirements put into place. And so typically, I serve guardianship petitions myself, or my associate serves them and reads them to the person. They can, you can have a family member or someone else do it, but if you are able to have if the family member can bring the alleged incapacitated person to your office, or if you are able to go to the home, it doesn't take very long. It really is a very important issue. And then when you file in addition to serving the alleged incapacitated person, you have to give written notice of the petition to they're so-called presumptive heirs at law, right? They're intestate heirs. If this person were to die today, who would receive their estate? And so in most VIP cases, it will often be the parents. If it is an older, if it's a parent or a grandparent, then it will be the children. And so for that, you look under Pennsylvania statute, and you can do a quick Google search, Pennsylvania intestacy, and it will spell out for you, who the sort of order of, who are the intestate heirs. And in addition, if the incapacitated person is living in a residential facility, a group home, some other care facility, you must give written notice to anyone who's providing those services. Why might that be? Well, because whoever is going to be put in charge of this person's money is now going to be the person who's charged with paying for the care that the incapacitated person is receiving. And so it's important that any facility or group home, what have you, in which the incapacitated person is living knows that a guardianship action has been filed, including so that they will know with whom they should be communicating with going forward. Next slide.
Thanks. So again, this is an incredibly serious and important proceeding that again is stripping the alleged incapacitated person of their constitutional rights. And for that reason, the court has to find incapacity by clear and convincing evidence. And the court's going to look at the nature of the condition and the disability that will impair the person's capacity to make and communicate decisions, and really the extent of the individual's capacity to make and communicate those decisions. And again, and we'll talk more about this in a few minutes, but the incapacity is proven through expert medical testimony. And we do that through a written expert report, and it's a mandated form from the Orphans Court, so you don't have to generate that, it's there for you. And it's not done by live testimony, with the exception being an emergency guardianship, but that's a very unusual proceeding. But we will get more into that in just a moment. So if we can move to the next slide. A couple of other things to keep in mind, because sometimes people get a little tripped up on this. Your client is the proposed guardian, not the alleged incapacitated person. Of course, you're very interested in the alleged incapacitated person, and that's who the proceeding is about, but you're representing the proposed guardian. And the court separately will consider whether the alleged incapacitated person should have counsel appointed to represent them in the matter. And so that's a separate determination, and we'll talk about the communication that you have with the court about that in just 1 minute. Are there any questions before we move on? What we'd like to do now, Tim and I have talked about this, that guardianship is very much a process. Step 1, step 2, step 3. It really follows that formula. And so what we like to do is go through all of these steps from start to finish and sort of walk you through what to expect and what you will be doing. But are there any questions just about the background that we've covered so far before we go on to some of these steps? Okay. All right. So
I want to make one quick comment. And again, this doesn't come up so much in VIP cases, but to the extent folks who are attending may also wish to or already handle other guardianship cases. One interesting thing about guardianship cases is that the sort of the first and most important issue to consider is even more important than is the person incapacitated, is does this person need a guardian? And so because there can be situations in which well, I mean, the most obvious one is if there's a power of attorney that's in place. But there is a case called In Re Peary from the Pennsylvania Supreme Court, and the site is 556 PA 125, a 1999 case by the Pennsylvania Supreme Court. And what I'll do is I'll send that to Denise, and maybe she can send it to everyone, because it really is interesting reading for anyone who does guardianship work. And so because it was a case involving a woman who had Down syndrome, and as I recall, I haven't read the case in a while, but but I believe her parents, who had sort of been keeping an eye on her when she had passed away, but she had a nice little life for herself, and she had sort of a community of folks who kept an eye on her, and who and so her affairs were the court ended up concluding, yes, she probably would meet the legal definition of incapacitated, but because of her network of support, there was no need for the court to impose a guardianship upon her. And so again, this case those kinds of issues will not typically present themselves in a VIP case, but it is always very important to remember that again, that just because of how critically important and the constitutional rights are involved, that the system, if you will, wants to really be sure that is a guardianship the only answer here. And so sorry about that. We can move right on.
No, it's a great point. So let's talk a little bit about what you should do once you accept your first VIP matter, which I hope you will do soon. So the first thing you do is you review the intake form, and that'll have all the basic information about your client, the proposed guardian, and the alleged incapacitated person. Of course, you need to run a conflict check on your client, the alleged incapacitated person, any interested parties, and prepare an engagement letter. So let's talk a little bit about that first meeting with your client. The first thing you need to do really is to explain the scope of your representation. You're helping obtain guardianship only, and you're not representing the proposed guardian for any other purpose. So your engagement letter should be narrowly tailored. You should be really, making that clear up front. You also want to manage expectations about the time this is going to take. In Philadelphia and in the surrounding counties, but for VIP, it will be Philadelphia. Guardianships take some time. It's going to, and part of this will depend on whether the expert medical testimony has already been gathered. But if that hasn't, that can take some time just in and of itself to get the doctor or doctors to respond. But even if you have that in hand, you'll need to prepare the petition, file it. There's usually the hearing isn't scheduled for about a month. You need to attend the hearing. So typically I would say you want to prepare your client for several months, 3, 4, maybe even 6, again, depending if you don't have that expert medical testimony in hand, and explain that it will involve a hearing at City Hall, which the alleged incapacitated person will also likely have to attend. And actually, I have a question for the group, and I'm the last guardianship proceeding I handled was in December of 2021, and that was done by Zoom. Do we know whether Philadelphia Orphans Court is handling these in person? I know we're still doing audits remotely. Are they doing incapacity proceedings in person yet?
I don't believe so. We just had one just 2 weeks ago, and it was done by Zoom.
Okay, and I see that. Thank you, Jennifer just responded that she just had one scheduled by Zoom for July. So it looks like they're still remote, which I think in many ways is going to make, well, there's pluses and minuses, right? Many of your VIP clients may have technological limitations and difficulties. They may not have a computer with access to Zoom. They may not feel comfortable. So it may require a little bit of hand-holding and assistance with that. You may want to offer to have them come to your office. On the other hand, as we are going to talk about, the alleged incapacitated person, unless there is a reason it would cause harm to the alleged incapacitated person, has to attend. And for many of our clients who are bringing the AIPs, that's very difficult. Sometimes, it requires, wheelchair accessible transportation, and parking is difficult by City Hall. So just the physical process of getting the AIP to City Hall can be daunting. So I guess, we have pluses and minuses with this new Zoom world that we're living in. But you do want to make sure, if it is going to be by Zoom, and we'll get to this, but that your client is comfortable with that, and maybe have some practice sessions, that type of thing. So if we can move on, please. So at this initial client meeting, obviously you're trying to gather as much information as you can about the disability and conditions of the AIP, what care is provided to the AIP. And I usually just ask about, describe the, your son or your daughter's typical day. Tell me about the care that's provided. You want to get a list of medical providers and contact information for those medical providers. And Denise, is VIP collecting the written expert testimony in advance? I know sometimes that's done, sometimes that's not, or is the volunteer reaching out to get that?
It's a practice I've instituted as kind of on a permanent basis for our team, is to try to get the expert report before we place a case with a volunteer.
That is wonderful. I just want to tell this whole group here that is going to make your life so much easier. I mean, that is a huge, huge part of it. You want to find out the AIP's assets and income. And typically, I would say for most, if not all of our VIP clients, that might be limited to Social Security benefits. And for that, you want to ask also who's serving as the representative payee for the alleged incapacitated person, because I think that that's also good evidence that the person who's the representative payee for Social Security is someone who's already acting really in a fiduciary capacity for the AIP and is showing responsibility with the finances of the AIP. We can move on. You want to find out about the adult relatives who would inherit if the AIP dies without a will. So again, this is what Tim was talking about with the intestacy statute. You want to ask whether the client, again, the proposed guardian, not the AIP, but does the client have any criminal or arrest history? And we'll talk about this in a minute, but that is a requirement now to become a guardian, is you have to provide a criminal background check. And so you want to know up front if there is a criminal or arrest history, and just find out a little bit more about it. And it'll be really important to figure out whether that criminal history involved any fraud or theft. If it's a marijuana possession from 15 years ago, I mean, don't worry about it. If it's embezzlement, you may have some issues, right? So you need to figure those things out. How does the client speak and communicate with the AIP? Is it, do they share the same language? That's important. And again, the courts have gotten rid of the requirement that the guardian speak English, but I think it is important that they share the same language and they can communicate. So Tim, anything to add before I turn it back over to you?
Nope, I think that was great, Kath. So, all right, so now as Denise just pointed out, in most instances, VIP will be very helpful and will have this report from you, but this is the step in a guardianship that tends to, that can delay the process. Because you need to present medical evidence about the disabilities of the alleged incapacitated person. Under the statute, that is through a written expert report of, is quoted in the slide, an individual qualified by training and experience in evaluating persons with incapacities of the type alleged by the petitioner. So that will typically be a medical doctor or a psychiatrist. Every now and again, you'll have a question of somebody, well, what if I have a nurse practitioner, or, and the general rule is, you should assume that report should be prepared by a medical doctor. That is who the judge wants to have, again, in light of the seriousness of this matter, that it should be performed in most instances by a medical doctor. Often, typically the treating doctor, especially in VIP cases, the person who knows this incapacitated person the best.
May I jump in for one moment,
Yep.
Tim?
Yep.
But it's far more important. A psychologist is also perfectly acceptable, or a psychiatrist, certainly, which is a medical doctor, of course. But the orthopedist that treats the person is not the best choice, right? Again, we're talking about mental capacity here, so you want to keep that in mind. And I have used nurse practitioners as well. Typically, there I've had two different experts, but I think that will, again, depending on their expertise, I think that could likely be accepted.
Kathy, and I just wanted to mention, we have run into cases where the expert report was denied because it was a nurse practitioner, but we've advised that it's okay if it's a nurse practitioner, but they should have their supervising physician sign off on it as well. It helps, because sometimes the nurse practitioner is the only person that knows the patient well enough.
Right. I mean, that's the, that of course is the irony, is that oftentimes, someone such as a nurse practitioner may well be the person who really, truly knows this person the best. But as Denise was explaining, and this is something that you will just run into in the orphans court, is, when you present a report done by anyone who is not a medical doctor, you need to be prepared right from the outset for the judge to say, I mean, does this person not have a doctor, counsel? Is there some reason why a doctor has not opined here? And so you want to go in prepared, and because and noting that the statute, of course, does not say, and that that person must be a medical doctor. That the statute says, an individual qualified by training and experience in evaluating people with these kinds of incapacities. And so, so you want to be prepared to, if you have a report done by anyone other than a medical doctor or a psychiatrist, or that, why it is that this person is in fact trained in evaluating this kind of disability and fits within the statute. In Philadelphia, the local rules require that the expert report be notarized. And so that's a very important, very, very important fact, is to make sure that when you present, if you are the one who presents the form to the doctor to be filled out, make sure that the form contains a notary block, including if you have to add it to the form, because that is a, if it is not notarized, there are judges who will not allow the matter to go forward.
And
next slide.
If there's any reason that you get a case and the expert report isn't already done and notarized, VIP will accommodate physician requests for assistance with notarization through e-notarization or traveling notary if possible.
Great. And so, and as I noted, I mean, that this is, whether it's, I mean, thankfully VIP, under Denise's great stewardship is really helpful in getting these reports to you, because as I noted, it really can be the sort of the most challenging part, getting the doctor's attention, getting the form to the doctor, getting it back, and then looking at it and saying, oh, you didn't fill out a certain, one of these questions, or it's not notarized. And so, but if you have a situation in which you need to get that report done and you're encountering any issues with the doctor, oftentimes ask your client, because your client will typically be the typical most direct client with the doctor. And sometimes if they either make a phone call themselves or go into the office, they may be able to get a little help that you may not be succeeding in by leaving voicemails with the doctor. Next slide. And so, really, as noted in the slide, guardianship really is a two-step process. Number one, is this person incapacitated? Number two, if so, who should serve as the guardian? Although, as I noted before, there's sort of an overarching number one question that says, is a guardianship needed? But in your VIP cases, these are really going to be your two critical questions. And usually, question number one will be in a typical VIP case will be very plainly obvious. Yes, this person is incapacitated, and so then the only question is who should serve as the guardian. And in my experience with most VIP cases, there is the person who should serve as the guardian is the person who VIP has brought to you as who has proposed to be the guardian. And so it's when in situations where there's a lot of money involved, there can be a lot of arguments about, well, who should be the guardian? Should it be one sibling or another, or should it be the second spouse, or as opposed to one of the children from the first marriage? There are all kinds of issues that can come up on that front. You will not typically see any of those in a VIP case. And so your goal here is to show, look, this person is incapacitated, they can't make decisions or communicate those decisions effectively, and your client is the best person available to make decisions. And that's where that client interview that Kathy was talking about comes in so handy, because it will give you some real life examples of, look, here's why my client is the best person to serve. This is what my client is already doing. My client, who has right now no legal title, is already, managing their care or handling their care, providing their care. And so again, it will typically be in a VIP case very easy to show both of those things. Under Orphan's Court Rule 14.6, the court, there is sort of a tiered, we look at who should serve. And so we begin with, did the person sign a power of attorney? And because in most powers of attorney will have a clause in it which says, if a guardianship proceeding is ever initiated with respect to me, I hereby nominate and appoint my agent to be my guardian. And the court will give preference to that, right? Under this idea that, look, and this will come up in a case in which, again, the person had capacity but has since lost it. And so here, your classic dementia kind of case. And so the court says, well, when this person had capacity, they decided that a certain person should be their guardian, and the court is going to favor that choice unless, and this is, I'm involved in a lot of these cases, unless, as it turns out, the agent is up to no good. If we can show that, well, the agent has been stealing, to put it bluntly, the incapacitated person's money, well, then I don't care what that power of attorney document says. This person should not be the guardian. And so that's the first, the first person in line. Next slide, please. If the alleged incapacitated person, as is going to be the case I don't know that I've ever seen a VIP case in which there was a power of attorney had been done. And so, so if there is no agent under power of attorney ever named, then, for the guardian of the person, first it would be the first in line would be the guardian of the estate, the spouse, unless they are estranged, an adult child, and if no children, then a parent. And then there's a little bit longer list, and there's an option for what are known as professional guardians. So there are folks who at sort of at every level of the income scale serve as professional guardians and who get appointed by the court. And that's the sort of the analysis is the same under either the guardian of the person and guardian of the estate. And in most VIP cases where you don't have a large estate, it will be unusual for the guardian of the estate and the guardian of the person to not be the very same person. But in other situations, you may have a situation where somebody has a lot of money, and the person who is best able to care for them physically has no business handling their money. And so the court will separate those duties out and will name one person guardian of the person, a different person or an institute or a different person or institution to be the guardian of the estate. You will not tend to see that in VIP cases. It will usually be your client will be seeking to be named and will be named both guardian of the person and guardian of the estate.
Exactly. And I think I had a recent case where it was siblings who were seeking to have guardianship over their incapacitated brother who had suffered a very debilitating stroke. And one was a nurse who sought to become guardian of the person, and the brother was a CPA and he wanted to be guardian of the estate. And that was perfect. That was great. But yeah, you really look at what those skill sets are in that case as well. So let's talk for a moment about what needs to be included in your petition. And we have provided to you a sample petition at Exhibit 5, and we're just going to walk through a little bit, if we can go to the next slide, what you're going to put in there. So obviously you're going to put in information about your client, the petitioner, their relationship with the alleged incapacitated person, and then some information about the alleged incapacitated person as well. So name, age, address. And you'll list who else are interested parties, right? Who of the alleged incapacitated person. Are they married? Are their parents still living? Who are the presumptive intestate heirs? And whether those presumptive intestate heirs have capacity themselves. Are they sui juris? Are they adults with capacity? And we included in here the site to the intestacy statute. And we also provided behind Exhibit 6, I think, a little bit of a cheat sheet for intestate heirs in Pennsylvania. So, and if you have a spouse or a parent or a close intestate heir who has died, I would just recommend listing them and explaining that they are in fact deceased. Again, we've mentioned this before, but if the AIP is living in a residential facility, you want to provide the name and address of that facility and make sure they receive notice. Put in there the names and addresses of other service providers and the types of services that they are providing. And of course, whether there's a healthcare or financial power of attorney already in place, because as Tim mentioned, that is a threshold issue, is whether this whole process is even necessary. Then you're going to get into a little bit about, about why we're there. What are the physical and mental conditions and limitations of the AIP, with much more of the focus, I would say, on the mental conditions. Someone can, of course, have very serious physical disabilities and limitations that don't affect their cognition at all, and guardianship would not be appropriate. So that's really where your focus needs to be. You need to have an averment about whether these conditions are permanent or temporary, because sometimes they could change, and if they are in fact not expected to change, guardianship is appropriate. If they are expected to change, maybe not. Maybe there's another mechanism. You have to state whether there's been a prior incapacity hearing. And then, of course, whether there is a less restrictive alternative to guardianship, and that you've considered them, powers of attorney, and that that won't work here. So that's why you need guardianship. You need to provide the names and addresses of anyone who should receive notice of the filing of guardianship reports. So again, that's going to be the presumptive intestate heirs, the residential facility, and any agent under a power of attorney or an advanced healthcare directive. Again, very unlikely on that last point for a VIP case. If you are seeking a limited guardianship, also very unlikely in one of these cases, you're going to want to list with specificity the areas of incapacity over which you're seeking a guardianship. So typically here, we're going to be seeking plenary guardianships over all areas. And typically you're going to be seeking to have your client appointed as guardian of the estate. And if that's the case, you also have to include a description of the AIP's assets, what they own, and their sources of income. You also have to put in there whether or not the AIP was ever in the armed forces, and if so, if they are receiving veterans benefits, which can feel, a little strange when you're talking about, an 18-year-old, now adult, adult child who has never had capacity, but it's an averment that has to be included. And then finally, you need to request to waive bond, and you can do that for good cause shown. And typically with a VIP case, I would say your good cause is that the estate will be of nominal or limited value. So for an estate of that size, typically I would say a bond is not required. Moving on, you want to include some of the qualifications of your proposed guardian. And with our clients, typically that's going to be, that they've cared for, again, I'm going to use the the adult incapacitated child as the example for a moment. And there I would talk about how the proposed guardian has cared for their child since their birth, and that they, they make all the medical appointments and take them to appointments, that they know their care. And even if they're not the person who is providing all of the care, perhaps they have care providers that come in and assist with that. They're arranging all of the care. And that they have no interest that is adverse to the AIP. You also, now this is if it's for someone who is not living with the AIP, whether they're able to visit with the AIP, whether they have any guardianship training or certification, and that's far less important with a family member. And then whether they've been guardian in any other matters, and if so, how many active matters do they have? These are really focused more on those professional guardians that Tim was talking about. And there's been a lot of issues with some of the professional guardians who were individuals, and a lot more safeguards that are being put in place, including the criminal history checks that we're going to talk about. Tim, did you want to touch on that at all?
Yeah, I mean, I think that I was focusing on for a minute on the issue of that the proposed guardian has no interest adverse to the alleged incapacitated person. So that would usually mean that they don't, so if they happen to be spouses who are in the middle of a divorce, or if they have if somebody had asserted some sort of a claim against the incapacitated person, what you'll typically note in your VIP petitions is, we will say the proposed guardian has no interest, and so because it will often be a parent of a child or the child of a parent, and so you will make the statement that the proposed guardian has no interest that's adverse to the alleged incapacitated person, although the proposed guardian is an intestate heir of the alleged incapacitated person. So it's not really, doesn't necessarily create a conflict, if you will, but it's a fact that you want to make sure that you're very open and upfront about, and you're already going to have to. You will have already identified them as such in your petition.
If I can just jump in there, what I'm about to say is incredibly obvious, so forgive me, but the reason being, of course, that as the guardian, they will be responsible for spending the AIP's money. And if they are an intestate heir of that person, should they die at that point, one could argue they are not going to want to spend the money, right? There'll be more left for them when the person dies. So that's but I think that courts see that all the time, and that's not an issue. And you're right, we just state that, although they are presumptive intestate heir.
And I'll just add that when we do our case screening, we also screen for folks who might be working for the incapacitated person as a home health aide or other kind of skilled nurse. Because, yeah.
Tim, Denise, have you, certainly I've seen many people, oftentimes parents are caregivers and they receive payment for caregiving. So I think as long as that's disclosed, that's not a problem.
That's right.
Okay, I think that was all I had. Moving on, I think, Tim.
Okay. So your additional requirements for your petition, you have to have in the orphans court uses a sort of 2-decree system, if you will, in pretty much all matters. Certainly at the beginning of every orphans court case, you have what's called a preliminary decree and a final decree. And so the preliminary decree, it's in Exhibit 5 of your sample, and it is what is issued when you file your guardianship petition. The court issues the preliminary decree, the purpose of which is to schedule the guardianship hearing itself, and it spells out the requirements about service, and because then what it talks about too is that a so-called citation is issued. And so a citation is the orphans court equivalent to over in the civil division, a summons. A citation is the piece of paper issued by the court that, when served on the respondent, creates jurisdiction in the orphans court over the matter. And so when the preliminary decree is issued, there will also be a so-called citation issued with it. And the citation is issued by the clerk of the orphans court. They will contact you when it has been issued, and will, I think in today's world, they tend to send it more. You used to have to go there to get it. But so in any event, you know, these forms that we've given you, they track what the Philadelphia judges are expecting to see in them. And so if you somehow believe that you should change some of the language in your proposed decrees, such as the one that that may come up might be in a VIP case, is well, what if you can't find an intestate heir? What if the intestate heir is a parent who abandoned this child, and who is, no one has seen or heard from this parent in a very long time? Well, you do first have to satisfy the court, satisfy yourself, so that you can satisfy the court that you did make a good effort to find this person. And so, because again, in light of the serious nature of a guardianship proceeding, if both parents are alive, then both parents should have notice that this guardianship proceeding is pending. Even if the one parent really doesn't like the other parent because the other parent has not been around for a long time. And so you may have, you may have a client who says, like, I can't even believe we have to, why would we have to find, him or her? Why would we have to find them? Because they have not been around. I'm like, well, and the answer is because it's important and because it's required. And so, but if you have made and are able to show the court that you have made an effort to find an intestate heir, but simply are unable to find that person, then you may note in your decree that, where it talks about how service will be made upon all interested parties, and you might make a note to say, except insert the name, whose location is unknown, and is unable to be discerned. There is a so-called guardian address confirmation form as an exhibit, and then you have to put that form into evidence at the guardianship hearing. Be prepared to hand it to the judge or to enter it, provide it to the judge via Zoom under the current procedures that they follow. That's in Exhibit 2, page 59. Next page. So Kathy mentioned this, the idea of that, look, there needs to be all guardians now are required to attach a certified response to the Pennsylvania State Police criminal records check. Of course, you redact the social security number that's on that form, and that criminal background check needs to be done within 6 months of the filing of the petition. There are very specific procedures to follow in here, and so that this is the sort of thing that we basically send our clients who are proposed guardians. We send these very specific instructions to them, because to make sure that that they don't get hung up on once they get on the website. You want to make sure that they're able to get through the website, and so that they can get the report form or get the report issued by the Pennsylvania State Police. There is also a form. It's the last 2 pages of Exhibit 5. You have to have the person needs to sign what's called a consent/acknowledgement of the proposed guardian to serve as the guardian, right? So I, Tim Holman, hereby agree, I consent to serve as the guardian. If appointed, I consent to serve as the guardian of the person and estate of the alleged incapacitated person. if the if the proposed guardian has some sort of criminal history, make sure that you address that in the guardian consent / acknowledgement form, and address it in the petition. Because as Kathy noted, not every criminal conviction is going to be a disqualifying criminal conviction. And so the court will be very much focused on anything involving fraud or a crime of dishonesty as it relates to being guardian of the estate. And certainly to the extent somebody may have been convicted of some sort of physical abuse type crime, well, then that's going to call into question whether they are a viable guardian of the person. I've never encountered that as an issue in a VIP case. When you are able to obtain the consent of the, if you have a situation of and where this you're proposing one parent to serve, and perhaps both the parents are divorced, but they are at least they are civil with each other, or at least they communicate with each other. And if you can get a signed consent from that other parent, then that is basically the gold standard, because at the hearing, you will be asked, okay, well, what is the position of the other parent? And so, as I say, ideally, you will have first been able to obtain a signed consent from the other parent, that they agree that your client can serve as the guardian. And if not, let's face it, sometimes people won't sign things, just to be difficult. Then fine. Well, as long as you have served them with the petition, and you can show the court that you have served them. If the judge asks you what's their position, what you would say is, well, I've not been able to contact the person. They've not returned my calls or what have you, but I served them and they're not here. And so that's their position, is they're not here. And so they are not here to object. And so that's how you would deal with that issue sort of in the courtroom. Next slide, please. All right, now, should the person be there, the alleged incapacitated person? Well, again, in light of the importance of this hearing and the rights at stake, by statute, the alleged incapacitated person must be at the hearing unless a physician or psychologist states under oath that the person would be harmed by being present. That is a question that is in the written deposition for the doctor to fill out. They are directly asked that question. Would it be harmful for the incapacitated person to be in the courtroom? And because you can imagine situations in which it would be, particularly folks who have dementia, but who are not so deep into dementia that they are incapable of understanding that, wow, people are in this courtroom and they're saying that I'm unable to take care of my affairs, or I don't, certain people can find that incredibly distressing and upsetting. And so their doctor may say, yeah, no, this person should not be, although they are incapacitated, they should not be in the courtroom because it would be harmful. And of course, you have other situations where it might be harmful for the person to be transported or what have you, that may make it inappropriate for the person to be in the courtroom. And that's why it's noted in there that if they can't be there, the doctor will note that. Now, if the expert report answers you get from your doctor are handwritten, make sure that they are legible, and consider having you or someone who works with you type them and send them to the doctor and ask the doctor to sign the typed version, because you don't want to have a situation where the judge says, I just can't even understand this writing here. I mean, that expert report is the critical foundation of your whole case. In addition to having a consent from a parent, you can also get what are known as, we provided you in Exhibit 7 to your package, so-called consent enjoinder forms for any close relatives of the alleged incapacitated person who agree that your client should be named the guardian of the person and of the estate. And so, and as is noted here, even though, even if you're unable to reach them by phone or by email, you must serve them, provided that they are intestate heirs under the statute with the petition via certified mail. Next slide. So now you're at a point where you are ready to file the petition. You have followed these fantastic forms. You have your written expert report. You have your any consents and joinders and consent of the parent. So now you're going to file as we file everything in Philadelphia electronically. And so we have spelled out here in this slide the sort of the public access policy of the case records public access policy of the Unified Judicial System of Pennsylvania, which is in effect, it applies to every kind of case, every case that's filed in the court system now. If you are going to attach, and particularly as happens in guardianship cases, we're talking about confidential information. We're talking about medical information. We are talking about financial information. And so ordinarily, if you are in the civil division, some other kind of case, or in the orphans court in any other kind of case, if you are going to be talking about confidential information, you have to redact it from your documents. You fill out a so-called confidential information form that includes the confidential information so that the court gets to see it. And then you submit the redacted version for filing, and you submit the confidential information form for filing. And so there had previously been a policy before January 1, 2022, where you would submit both an unredacted version of a document and a redacted version of the document. Those rules were changed as of January 1, and you no longer submit unredacted versions of documents to the court in any case. And we've given you the link that explains in greater detail that change. Now, what's important for you folks to understand, though, is guardianship cases in Philadelphia County are 100% confidential. And so you cannot go on the docket. No one can go on the docket and see any documents which were filed in a guardianship case. And so therefore, although your guardianship petition definitely will contain confidential medical information and confidential financial information, you do not have to submit a so-called confidential information form or confidential document form. And so that is a one benefit of being in a guardianship case. And that's in guardianship cases only, because otherwise in other orphans court cases where we are talking about medicine or money, we have to follow the same rules as everyone else. But it's just these guardianship cases that they've just decided, look, here's how we're going to handle those. Everything is going to be confidential immediately. And so you can't get it online, and you can't get it if you go to the courthouse and go, if you were to walk into the clerk's office and say, I'd like to see this guardianship file, they will say you cannot see it. Next slide, please. And so, but part of the public records access policy is you must attach a so-called certification of compliance with the public access policy, and that is at Exhibit 8. And so you will in all cases, including guardianship cases, you must fill that out and attach it. So in Philadelphia County, you will file your petition electronically. That's at Exhibit 9, has very detailed instructions on e-filing it. You will receive the so-called preliminary decree. Because that's another interesting thing about orphans court practice. Whereas in the civil division, if you file a complaint at 10 a.m. And get a timestamp copy, you can serve that at 10:05 a.m. In the orphans court, when you file your document, you can't do anything until the preliminary decree is issued. And the preliminary decree will not be issued until an orphans court judge or their law clerks, I'm not sure exactly how any given judge allocates it, reviews your petition and confirms that it has everything that it needs to have in it. And so there will be some delay between the filing of your petition and the issuance of the preliminary decree. It varies. Sometimes it's a couple of days, sometimes it's a couple of weeks. And so you don't need to get, don't be surprised if there is some delay from the time that you file the petition till the time that your preliminary decree is issued. And so you'll get electronic notification of that. And then the clerk will advise you that citations have been issued. And if I'd say that the traditional practice was that you would need to literally pick up the citations from the clerk of the orphans court. You also you can send them a self-addressed postage prepaid envelope. And so because the citations, but it's still a little bit old school, they have a raised seal on them. They are something that, it is this document that creates jurisdiction in the court when it is served. And so I do think that you will have to get the original citations either by going there or having them sent to you. And so when you serve the alleged incapacitated person, you have to serve them with the citation, the preliminary decree, and the petition itself. And I'll turn it back over to Kathy.
All right, great. Any questions about the process so far before we move on to the personal service? Okay, so you're now at the point you've received your preliminary decree back from the court, you've received the citation, you are ready to make that personal service on the alleged incapacitated person. As Tim said, I do this myself. I know there may be some practitioners who rely on a family member or someone else, but I think it's very important because I'm going to certify to the court that this was done, that I do it myself. And so I either go to the alleged incapacitated person's home, or if it's feasible, have the AIP come, usually with my client, to my office, and I read the petition and explain it in the simplest terms that I can. It can feel awkward, particularly when you're reading a petition or summarizing it / reading it to someone, for example, who's completely nonverbal. I mean, that they can't understand this information, but it's what you need to do. And in many ways, it's the hardest part, or perhaps the most awkward part of this process, but it's incredibly important, again, because we're stripping constitutional rights from someone. And so we have to do what we can to make sure that they really have received that notice and they understand it. One important, very important part of this process is that that personal service has to be done at least 20 days prior to the hearing. So what's really important about this is that you need to give some thought as to when you are actually filing. Because as Tim said, it takes I've typically found it takes 3 days to a week to get it back. I haven't had it so long as 2 weeks, but maybe, yeah, that's certainly possible. Hearing dates are often scheduled only about 4 weeks out from the issuance of the citation. So if you work backwards, it's not leaving you with a whole lot of time to do that personal service. And so if you or the client or the AIP is going to be away, or has surgery scheduled or something where they're not going to be available, you may want to hold it and wait until that window is a little bit clearer so that you can get that personal service done. There is a mechanism called an alias citation. We won't go into it, but hopefully you won't need it, where if you need to get additional time, you can reach out to Tim or to me and we can walk you through that. It's not difficult, it's just a pain. So if you could get it all done the first time, that's going to make your life a lot easier. Moving on to the next slide. So another important deadline to keep in mind is that at least 7 days before the hearing, you also need to provide a letter to the judge explaining if the alleged incapacitated person has counsel appointed, and if not, whether has counsel, and if not, whether the AIP needs counsel appointed. So we've provided for you a sample letter that I think is the typical letter you're going to send in a VIP case. And I refer to it as the no counsel needed letter, which is basically under these circumstances where incapacity is very clear and where this is a family member who's been caring for this person, again, in the adult child scenario since birth. Here, there is no reason that counsel is needed. Now, this becomes tricky, right, with someone who has capacity and has lost it, who's denying that they've lost capacity. If they have millions and millions of dollars in the bank, and you think somebody might be trying to, pull a fast one and get guardianship so they can take control of grandmom's money. These are not your VIP cases. Their, counsel is often appointed and probably should be appointed. And again, it's a protection that's put in place. You'll put together all of your documents and prepare an affidavit of service. We gave you a sample affidavit of service. It'll have a copy of the citation with notice and also include the certified mail receipts from serving the family members, if you have any.
But and I'm just going to comment on that issue of the so-called no counsel needed letter. It's very important. I mean, you do not want to show up at that hearing without having sent that letter and having the judge ask at the hearing, is there counsel here? Or did you send me a letter? And so it's the kind of thing. Put it in your calendar. Once you have the hearing date set, and make sure that you send that letter. And because in Montgomery County, for example, counsel is appointed for an incapacitated person in every case. And so Philadelphia County, the logistics of that would be, would be daunting. And so, there's so many guardianships filed in Philadelphia that is not what happens in Philadelphia. And as Kathy noted, in your typical VIP case, there is no real dispute about either incapacity or who should serve as the guardian. The courts will not insist on the appointment of counsel in those kinds of situations, but you do have to send that letter.
So thanks, Tim. That's a really good reminder. Yeah, the 20-day personal service deadline and the 7-day, no counsel necessary letter are really, two very important deadlines to calendar. So then you want to prepare for the hearing. So you're going to prepare your client, the proposed guardian, and any other family members you may want to attend. You want to, I prepare a direct examination the way I would for any other case. Again, there's no one on the other side, though, who's going to be doing a cross-examination. So a little bit of the pressure is off. If the hearings are back in person, go through, this may not seem like a very big deal to you, but it likely is to your client. So, walk them through it a little bit, explain to them they'll need identification to get into City Hall. Do they know where they're going to park? Do they need help finding a parking lot that will accommodate a wheelchair accessible van? Those types of things. They may have questions about what to wear, how early they should get there. So, keep in mind that they may have some nerves about testifying that day. And so try to do your best to reassure them. And of course, all of these things are slightly different, but the same idea of reassuring them and making sure they understand the process for the Zoom hearing is also important. The hearing itself is very informal. It's relaxed rules of evidence. The first thing I do is to after introducing myself and my client, is hand up the affidavit of service. And you want to e-file that prior to the hearing as well. I then, depending on the judge, some judges may sort of take over and just read into the record certain things, but if they're allowing you to run with it, then I make sure that I introduce the medical testimony yet through the expert report. Here is a big tip that I learned the hard way. I had been before several judges that just allowed me to describe in a general way the medical testimony from the written, they used to be called written deposition, but the expert report. And then I came across one judge who is still in Philadelphia County who said, please share with me all the important parts from the expert report. So I had to stumble a little bit and try to figure out on the fly, all, without reading the whole thing, what the important parts were. So I always highlight the relevant sections, the really important parts of that expert report in advance, so that if the judge wants you to put that into the record succinctly, you can do that. So learn from my mistake. And then you want to call your client to testify and go through your direct examination. It's very straightforward, simple. I usually tell my clients, don't worry. This is, you're just testifying about your life, about the care you provide, for example, to your child or your loved one. So don't be nervous, and they always do great. So
yeah, I mean, yeah, and that's it. I mean, it really is. The typical, VIP guardianship case, it would be is kind of the very definition of what I think of as a friendly hearing, right? We're all there to help the incapacitated person and to help this family obtain the necessary guardianship so that they'll be able to continue to provide great care to this person. And so although any given judge on any given day may be a little persnickety about the report or some detail, as a general rule, they're always going to be very gracious with your client, with you. It's, it is a, it is not, they are just a very friendly hearing, unlike a lot of the cases that I handle, which are very unfriendly, nasty, ugly, contentious, family battles, but when in your typical VIP case, it's a very feel good sort of event. And you're not going to be asked hard questions that you can't answer. The judge is not going to put you on the spot, except perhaps to say, read me the important stuff. So now that you have that tip, you're going to be fine there. And so, okay, now you've gotten through your hearing. You will, in pretty short order, receive a so-called final decree appointing a guardian. As with the petition itself, that final decree needs to be read to the alleged incapacitated person, who's now indeed and so the caption of the case will change from Jane Doe AIP to Jane Doe IP, because Jane has now been decreed to be an incapacitated person. And so that final decree, which also is a, it's a statutorily mandated form, local and local rule driven form, and we have the obviously you have it in your exhibit, your form book there, explaining to the person, okay, you have been declared to be an incapacitated person, and it explains to them their appeal rights. And so again, so that needs to be, that one typically I do allow the client to read it. But there are times when I read it to the incapacitated person myself, depending on timing and scheduling. It has to be done. That has to be done within 10 days. And so so usually you send it to your client, have them read it, and have them confirm that they have read it, and then you have to file an affidavit of service of the final decree. And so we have an exhibit 13 in the materials is your sample, and exhibit 14 contains the instructions on how to file that document electronically. And so in here, where VIP it can be very helpful in making sure there's a notary available. If your client needs to sign that affidavit of service and needs a notary, VIP can be very helpful with that. And so, okay, well, now once that final decree has been served, this is very important. Basically your work is done. And so you want to now send a so-called closing letter to the client explaining, okay, now that you have been appointed guardian, my representation of you has come to a close. And so that's important for lots of reasons, including malpractice. You want to make it very clear. Look, so going forward, you're now the guardian, and so but my representation has ended because I was retained for this specific purpose to get you appointed. And so there is the sample closing letter in your file. You do also want to give, because the thing is, although your work has ended, your client's work vis-a-vis the guardianship system, if you will, has just begun. And so because guardians have their various requirements upon them about how do they handle a guardian's money, and they have to file reports with the court annually as a guardian of the person and guardian of the estate. And so helpfully, there is a so-called Philadelphia Guardian's Manual. And that's in Exhibit 16 of your materials. Always make sure to check online for because that is the kind of document that's updated periodically by the court. And so, send that to your client and explain to them the importance of reading that manual carefully and complying with what is set forth in there. Next slide, please. Because as I was just saying, it's so important that your client understands, and you also, you're going to want, of course, to talk about this even before you file the guardianship action, to make sure that your client understands that, look, this is not some one and done situation. We're going to get this, we'll get you appointed as a guardian, but going forward, you're going to have this obligation to file these reports with the court. And so they have to file first an inventory within 3 months of their appointment, listing the assets of the incapacitated person. Again, in a VIP case, typically there will not be significant assets, but whatever there may be, just shows up on the inventory. And there may be none. They may have no assets in their individual name. If they, if they're if they have been incapacitated since birth, they may not have any assets, but they may start to receive Social Security benefits in their own name after they turn 18, and that may have happened by the time you file your inventory, and certainly by the time the guardian files their annual report. And you want to explain to the guardian, that look, you cannot spend so-called principal assets of your ward without obtaining prior court approval. And so again, and in most VIP cases, this is not going to be a big issue, because to the extent that the incapacitated person has assets, they will tend to be in the form of income. They will receive a Social Security check, which is income, and the guardian is able to spend income without obtaining court approval. But if they happen to have some amount of money, whatever it is, $20,000 in a bank account on the day that the guardianship was created, on the day the judge issued the decree, the guardian cannot touch that $20,000 without asking the court for permission and explaining to the court, here's what, this is what I would like to spend this money on, and why. And so then you will file your, to make sure that everything is very clear, you will actually file a formal withdrawal of appearance. And that's in Exhibit 17. And then Exhibit 18 gives you the instructions for electronically filing that document. Next slide, please. You will also, as part of a guardianship decree, among the obligations of a guardian is to, if the incapacitated person had done a will, so again, this will be in the situation where it's an adult who had capacity but who has lost it. If when that person had capacity, they signed a will, then you need to file that will with the judge within 30 days of your client discovering or locating that document. And so why? Well, you can imagine why. We'd like to, we want to know right now, does this person have a will? Because we don't want to have one just magically show up later on out of the blue. Next slide, please. And so, so now Philadelphia has what's known as the guardianship tracking system. So it's a statewide system. And so, which, as you noted, you can file the inventory, you file these annual reports, and you have to file these documents online. So it's, so again, as Kathy had mentioned, any number of VIP clients may be technologically challenged. And so, but this is the only, they must obtain an email address and they must file these documents electronically. They do not have an option of filing them manually. And so this is something that you're going to explain to them, and to the extent that they need help with that through VIP or what have you, then you want to make sure that VIP understands, look, my client who was just named Guardian does not have an email account, and they're going to need help getting that set up. And so and there's there's the link, there's the website address there that spells out, it shows where the system is. This is Kathy.
Okay, so it's time to just step back for a minute and just recap. As I said, this is a step-by-step process. And what we've tried to do is give you the overview and the background, then a little bit more detail about each of these steps. And now we're just going to go through so that you have a list of what needs to be done step by step. So hopefully when you receive your case file, you will have an expert report from the doctor or doctors. If not, that should be your first step after your initial meeting. You'll obtain a Pennsylvania criminal history report for your client and then draft your petition. Have your client review it and sign the petition. And then you'll attach to your petition any signed consents and joinders from interested parties and a certificate of compliance. You'll e-file it, and you'll then get your citation and preliminary decree back from the court. Review your preliminary decree carefully, look for instructions and deadlines from the court that has everything in it that you need. We can go to the next slide. You'll then personally serve the petition and citation on the alleged incapacitated person at least 20 days before the hearing. And then that same day, serve the petition with citation and notice on all interested parties. You'll prepare your affidavit of service to hand up at the hearing, and ideally you should e-file it before the hearing. And then you send your letter to the court about no counsel needed at least 7 days or more before the hearing. You prepare for the hearing, review the direct examination questions with your client. And then we can move on. And then, Tim, is this you? I think this is you.
I think it is, yeah. So right, so you'll attend your hearing. After the hearing, you will, in very short order, receive the final decree from the court. You want to review that carefully. Again, looking for the instructions and deadlines from the court about, filing an affidavit that you served that final decree, or confirming an affidavit of whoever served that final decree. You want to then make sure to serve the final decree, whether yourself or your client or someone else. Speak with your client. And at this moment in the life of the file, they're about to become your former client, but speak with them about their role and their responsibilities, and file an affidavit of service demonstrating that final decree was served on the incapacitated person, and then file your withdrawal of appearance. And the next slide. The entire Philadelphia Guardians Manual, there's a link there to the, it's on the phila.courts.gov website, and you may want to check out, if you Google Guardianship in Pennsylvania, the Disability Rights Network of Pennsylvania, it's a very useful resource for you and for your client.
And one final step that we forgot to mention, which is then reach back out to VIP and ask for another case, because I promise you, this will be rewarding. It will be much, much easier the second time. It feels like a ton of steps, but if you do one of these, you will be an expert, I promise. The next one, the number 2, will be easy. And Tim and I are here to answer any questions. All the blank roamers on this training, I will partner with you and we'll take a case together, and I promise it will be great.
Yes, that's it. I'm always happy to serve as a mentor to VIP volunteers, and because in in any given case, there may be some question that pops up that isn't something that we covered today, because it's, as we all know, every case is unique. And so there are at this point, I've been doing this, and Kathy's been doing this for so many years. There are fairly few issues that come up that I have not seen before. And so I'm always happy to help any VIP volunteer give great service to their clients, and really, it really is. It's your clients will be so grateful to you. You are really providing such a great service to them when you help them with the guardianship case. And VIP is just fantastic in helping vet the whole situation and help with the getting documents and so on. And Kathy and I are always happy to answer any questions that may come up.
Thank you both. So I'll leave the floor open for any questions, but I also did want to note, just as something we also started doing to help our volunteers out, we send a letter out to the clients after we do intake, which kind of discusses the process a little bit and then addresses their roles and responsibilities once appointed guardian. And I ask that they sign it back. They don't always sign it and send it back, but at least we know they have that letter, and it'll be in the file for anyone new to guardianship that wants to reference that when discussing roles and responsibilities with the client. And if no one has any questions, I'm going to sneak a question. And so we thought this would be helpful to know, even though we kind of try to do the guardianship expert reports up front. From time to time, we see an issue with physicians requesting a fee for the expert report. Have either of you encountered that? And how would you suggest that a volunteer address that for a low-income client?
I have not seen that in a VIP case, and so, but if I did, I think that what I would say is something along the lines of, Doctor, believe me, I understand how valuable your time is, but this is a family. I am representing this family at no charge. Because this is a family that simply is unable to afford to pay. They're unable to afford to pay me to handle this case, and frankly, they're unfortunately unable to afford to pay for a report to be prepared. And so I would ask, out of the kindness of your heart, that because they may say something along the lines of, well, it's my standard practice, I always charge a fee, or whatever it might be. Is that idea of, I'm just wondering if you might be able to make an exception in this case for this client who needs the report, and particularly if it's the treating physician, it's the person who is who is in the best position to answer this, is to say, I would just please request that you waive that fee. And I'd be surprised if you put it to them that way, if you can convince them to come around. And if so, and if you have a problem, I'll get on the phone and call the doctor myself.
I love that, Tim. I would also suggest really trying to brainstorm with the family and figuring out if there isn't another medical provider who maybe would be more generous to do it free of charge. But I agree with Tim, trying to appeal to the provider is a good first step as well. And I too have not actually had that problem in a pro bono case, but I would imagine it could certainly happen.
Thank you both. There is a comment in the chat from Jennifer.
Yeah, I see that. So I have not had a, I know my associate recently had a case involving an interpreter, and unfortunately he's in a Zoom court proceeding right now, or I would reach out to him. And so I don't, so I've not had to deal directly with this issue, about the fact that the law has changed. And so, but as I say, I think that it's, these, again, always remembering that in these kinds of cases, it's not you know, judges ordinarily are not looking for a reason to deny the relief that you are requesting. And so I think that, you know, if you can as gently say, to the extent that any given judge may say, well, wait a minute, like, how can we appoint this person? They don't even speak English, I think that, that a gentle citation to the statute to say, judge, it's not, it is no longer, it's no longer required, should suffice. And in terms of, the process of obtaining translators to the court, I do think that that's something that you could take up. One thing that you'll find about the orphans court is that and particularly, I mean, you want to, law clerks can be helpful in addressing a question like this, and particularly, they will be receptive to a call, and especially if you find a way to say fairly early on, I'm assisting this client through Philadelphia VIP, and so and my client does not speak English, and my client needs an interpreter. I think that you'll find that the law clerk can be very helpful in directing you and your client to make sure how to make that happen.
And I would echo that. I actually did have a case back in December that I mentioned was done by Zoom. It was before Judge Heron in Philadelphia. We only have 4 orphans court judges, and Judge Heron was fine. We had an interpreter. My client spoke Spanish. The Judge Heron's assistant, Tina, helped set up the whole interpreter. I didn't have to do anything, which was a delight. And it was actually quite easy. So that's not to say that all the judges are going to be, and obviously it sounds like there is an issue, but at least with Judge Heron, it was not.
And again, and that's the kind of thing that, if you get thrown some sort of curveball like that, because even if, I mean, the worst that's going to happen is the judge is going to say, I'm going to defer this for some period of time, until this, if the judge is concerned about an issue like that. They're not typically going to say, slam the gavel and say denied, they're going to say, all right, I'm going to, and so if you ever perceive, something like that, if you're actually at the point where you're in a hearing and some sort of odd thing like that has occurred, you may, and if you're unable to convince the judge, what you should feel free to say is that if it's clear to you that the judge is otherwise perhaps thinking about not granting your petition, feel free to say, Your Honor, if we could please adjourn this hearing to a later date so that I can address Your Honor's concern, they will do that for you. Because that's one nice thing about the orphans court, right? Where we have no juries, these are bench cases only. And so the judge in that scenario will always be happy to say, fine, you know what, I'll bring you back in a month. And that's when call me, call Kathy, we'll help you get through that situation.
And on the language issue, and again, I'd like to hear more about specifically what the judge was concerned about, what was said. I think I would probably develop some evidence and some testimony about how the client has already been providing these. Again, I don't know the circumstances specifically of this case, but if it's an adult child, that this parent is already dealing with the with the doctors and the medical providers and the school and doing all of those things, and it's not an impediment, which I think would be true in our society today. So I'm guessing that that's the judge's concern, right? Is that the judge is thinking if you don't speak English, you can't provide this support. And I think if you can show, I mean, again, that is not needed according to the law, but also that could help as well. Any other questions? Well, thank you again. I really want to encourage everyone to take a VIP case, even if this seems daunting, which I hope it doesn't. It will be much simpler, and you have everything you need in these documents I do believe. So hopefully this will walk you through it. And if not, reach out to us and we will talk you through it over the phone
Or by Zoom.
or by Zoom. Exactly. Or
Thank you.
hopefully in person at some point.
Yeah, some point in person. Yeah, thanks everybody for attending, and thanks for your willingness to help VIP's clients. It's such an important organization. It's such an important thing to do.
Thank you, Kathy and Tim, very much for giving us such an excellent presentation today, as you always do. It's always appreciated, and we always appreciate the uptake in volunteer support after these presentations. So thanks again to everyone who attended, and it's 12:30, so I won't linger and keep anyone longer than they want to. So thank you all again for attending, and have a good day.
All right, thanks everybody.
Thank you. Take care. Bye-bye.